Jamal Coleman, I take it 9, 4 down.
I'm sorry, page what?
Page 9, so we're trying to get 4 down.
Jamal Coleman.
Morning, Judge.
Good morning. How's it going?
Pretty good. How are you?
I cannot complain. It's well, they tell me it's supposed to be extremely hot day.
I'm 15.
Yeah. So I tried to do a little linen today. All right. So how's everything going?
Everything's going good. I recently got my medication. They gave me a shot. I have to go back to the Center for Healthcare Services on the 26th.
All right, everyone, please whisper. Sorry, what?
I have to go back to the Center for Healthcare Services on the 26th to meet my probation officer. I also have a provider's appointment on the 26th, and then on the 1st I get another shot for the medication. I've been able to find some employment, mostly temp agencies. So when I request the schedule, the temp agencies, so some of them make them first come, first serve, and they already have standard workers, so I haven't gotten a chance to really go out. But yesterday, I got an email from AutoZone. That's the company that I used to work for. They're supposed to be rehiring me, and then yes, ma'am. And then I got another job. It's called Musket Corporation. All they do is box diesel fluid, and it's on an assembly line, and that's scheduled from 7 to 4. So I've been pretty good. I've been working on and off trying to find the right job around the schedule curfew.
Okay, well, I tell you what, be very careful with the diesel. Loading that.
Yes, ma'am.
Don't let somebody say, oh, I'm just going to smoke a cigarette. And so do we want to keep him on? Can we?
Judge, Mr. Coleman has finished his parenting classes. Since he's been released, there were some concerns from his probation officer as far as not getting some documentation and as far as his work is concerned, but he did show me the documentation and sent me some via email that I'll scan into the system. He has been following the guidelines of the GPS. He's not had any violations or anything like that.
So let me ask you, because I have him on curfew, right?
Yes, Judge.
So can we move towards just tracking?
So Judge, I was going to ask for either tracking or just straight up removal. If the court is inclined,
See, here's the thing.
maybe tracking for 30 days.
I like to do things in step by step.
Yes, ma'am.
So you've been on curfew. There have been no issues with curfew. So what I'll do is I'll do tracking only. So there's no curfew.
So I can leave whenever?
Yes.
Okay.
So it'll be tracking, but continue to do everything that you need to do. And then what we'll do is we'll do another update with you. And if there are no issues, I will remove it. So whether or not it gets removed at our next setting is completely in your hands.
Yes, ma'am.
All right. So when do you want to come back for that?
So Judge, since I'm asking for it to be on tracking for 30 days, I would ask for us to come back in 30 days.
Okay.
And I am also asking that if he is at work or employed at that time, that he appear via Zoom.
Are you able to do Zoom?
Yes, ma'am.
All right. So you won't have to come into court. You can do Zoom. And we will do tracking only.
Thank you.
You're welcome. You're doing great. I'm so proud of you.
And Judge, I just have one more request. Since he has finished his parenting classes, I'm asking that we give him credit for a part of his community service hours.
Okay.
And then upon completion of his BIP class, I'm requesting that the remaining hours he gets credit for.
Yes.
Thank you, Judge.
Thank you.
All right. It's too hot to be working outside. And I'm going to tell you what my mom told me with my very first job. Read the pamphlet, know the breaks that they're supposed to give you, okay?
Yes, ma'am.
All right, Norma, if I can have a 30-day reset.
July 20th.
All right, so we'll be back on July 20th. You can appear by Zoom. And then if there are no issues, your GPS will be removed.
Thank you so much.
And then you'll receive the credit for completion of the parenting classes. And then you say he has BIP as a condition?
Yes, Judge. that was given as a condition.
It's a 4 month, 4 month. The BIP is kind of a struggle on me because I don't have it. Without employment,
We're gonna take care of that right now. Because I know that there's an issue with the pricing. Can we, because is he on BIP?
So, hold on one second, George, I'm so sorry.
Because can we, if he is on BIP, can we just change that to an anger management class or something that is? Because I really don't think that that's the issue. I think the other issue had to do with medications.
So Judge, when he was first granted probation back in 2020, that was a condition. It wasn't something that came up afterwards.
All right, so this is what we're gonna do. Vashon, change it to anger management. BIP is very expensive.
Anger management.
And so you just do anger management class, and I'm gonna note that the reason why the court is changing that is due to financials.
thank you.
You're welcome.
Anything else, George?
No, that's all.
Thank you, Judge.
All right, guys, today we step into a real courtroom where one man's honesty earns him real trust from the judge. Jamal Coleman stands before the court, not hiding from the system, but working within it. He's juggling medication schedules, healthcare appointments, and job hunting all at once. Despite setbacks with temp agencies, he lands 2 job offers, one from AutoZone, his former employer, and another at a manufacturing line. He's completed his parenting classes and followed every GPS guideline without a single violation. His probation officer confirms it. No issues, no red flags. The judge notices this consistency and eases his restrictions, removing his curfew entirely and shifting him to tracking only. She even adjusts his expensive BIP class to a more affordable anger management course due to financial hardship. This is a rare moment in court where genuine effort and transparency directly translate into real relief. It's proof that the system can work in someone's favor when they show up and actually do the work asked of them, day after day.
Ms. Bellinger, I'll wait to the front for mine.
Thank you.
I think bottom right.
And Cindy, I see you put butterscotch up here for me. Thank you. Hello.
Hello.
How are you doing this morning?
Again.
Okay. All right, the court is calling 2025 CR 001934 State versus Mary Arlene Ballinger. Can I have parties announced for the record for the state?
Lauren Espinoza for the state.
For the defense?
Secretary Ayala for the defense, Your Honor.
All right, are you Miss Ballinger?
Yes, ma'am.
Did you review this document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it? You need to say yes or no.
Ma'am.
All right, are you the same Mary Arlene Ballinger who was placed on community supervision in 2025 CR 001934 for the offense of possession of a controlled substance penalty group 1 less than 1 gram on March 24, 2025 for a term of 3 years? Is that you?
Yes, ma'am.
State?
Violated condition number 43 on or about the 24th day of April 2026 in Liberty County, Texas. The defendant, Mary Arlene Ballinger, did then and there fail to comply with the rules, regulations, or instructions of the Bexar County Community Supervision and Corrections Department Substance Abuse Felony Punishment Facility Continuum Care of Treatment Plan, in that the defendant signed 3 refusals of treatment due to refusing the program and signing 3 program refusals. The treatment team recommend a program removal and CJAD approved in violation of condition number 43.
How do you plead to that, true or not true?
True.
Did you understand by pleading true to violation of condition number 43, the court could find it true, grant the motion, and sentence you up to 2 years in the state jail facility and up to $2,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition 43?
Yes, ma'am.
Court will find violation of condition number 43 true. Is there a proposed agreement?
Yes, Judge, the proposed agreement is to grant state's motion, amend the underlying adjudication and sentence to 14 months in the state jail.
Are you asking the court to follow that agreement?
Yes, ma'am.
Are you waiving your right to appeal?
Yes, ma'am.
All right, the court will revoke, sentence you to 14 months in the state jail facility. Give you credit for any time served. There's a $2,000 fine. Time and money will run concurrently. And I'll request the therapeutic community for you. The therapeutic community doesn't increase the time that you're in custody. It's designed to help you with any drug issues or
Okay.
mental health issues that you may have. Because, did you understand?
Yes, ma'am.
All right. Did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney, and the court is also going to order no unsupervised contact with minors. All right, your excuse. Thank you.
Have a seat, ma'am. Over there.
In this section, the court turns to a far more serious matter, a motion to revoke community supervision. Mary Arlene Ballinger stands before the judge, having been given a chance at treatment through a structured rehabilitation program. But instead of engaging, she refused the program 3 separate times. The treatment team recommended her removal, and the violation was formally filed against her. When asked how she pleads, she admits true, accepting responsibility for failing to comply with her conditions. The judge lays out the consequences. Up to 2 years in state jail and a $2,000 fine were on the table. Instead, a plea agreement is presented, reducing her sentence to 14 months in state jail, with credit for time already served. She agrees to the deal and waives her right to appeal. The court also orders her into a therapeutic community program designed to address any underlying drug or mental health issues, not as punishment, but as support. It's a stark reminder of how quickly missed chances can escalate into serious legal consequences for someone already struggling.
Sierra Diaz.
She's in the box.
Right here.
No, we said, she wants
May I
to come back.
present to the court a motion?
What page is this on?
She is on page 9, 3 down, Judge.
All right, court is calling 2026 CR 0048588 State versus Sierra. Sierra Janelle Diaz. Can I have parties announced?
Marshall V. White from Ms. Diaz, Your Honor.
All right, there's been a request by the defense to set bond. Are you Ms. Diaz? All right. Any evidence, state or defense?
No evidence in Sierra.
This actually, she has a judge's warrant and remand without bond because she was a no-show.
Yeah, and that's the thing, Judge. Ms. Diaz got caught in some confusion. She was at the courthouse.
Oh, so here's the thing. I'll need to hear testimony because under the new law, I have to make a decision on whether or not she willfully failed to appear. And if she willfully failed to appear, can't set a bond. Can you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Here, Janelle Diaz.
All right, you were due to appear on June 11, 2026. According to the court record, you failed to appear. Why did you not appear?
I did appear, Your Honor. I had went to County Court 12 where my attorney that was appointed to me had told me to go to. When I went, the doors weren't open, so I called the number on the back of the door. It's an invalid number. So I had to call and find the actual number to the receptionist down here in the courthouse. They told me I didn't have court at all today. I asked if she could check other courtrooms. She said, no, I didn't have court. so I got the okay to go home.
Okay, all right, the court will find that the defendant did not willfully fail to appear. Now we can move on to the setting of a bond. So, what is her criminal history?
Judge, she doesn't have any criminal history outside of the case that she's currently charged with, and then from the same criminal offense, she had a misdemeanor out of the same criminal transaction.
All right, have you ever had any mental health diagnosis?
You gotta speak up, okay, she's taking a record.
Oh, Your Honor.
All right, have you ever been admitted to any hospital for any mental health crisis or any mental health
No, Your Honor.
diagnosis? All right, have you ever, I'm not talking about now, in the past, have you ever used any type of drug? Marijuana, nothing.
As a teenager,
That's what I'm talking about. I need to know because I have to set conditions. So have you ever used any type of drugs in the past? When I say that, I'm not speaking about this specific case. I'm not asking you questions about this specific case. I'm asking you questions so that I can set conditions of your bond. So have you ever used any type of drugs in the past?
yes, sir.
And what would that be?
CBD.
Okay, anything other than that? All right, so you both are requesting a bond or have agreed to a bond of $4,000?
Well, Judge, respectfully, I mean, that's what the state's position is, but Ms. Diaz was on a bond, I think, of $2,000, and you heard her give testimony about why she missed court. So,
All right,
we
the
would
court would set the
respectfully-
bond at $2,000. And that was the previous, because that was the previous bond amount.
That's my understanding.
Just so the court is aware, the reason that the state was in agreement to setting the bond, I know the court already made the finding, but regarding, I think what she was speaking about is her misdemeanor case was set. And that court was sua sponte resetting the cases, and then also the attorney that she had in that case has been removed from the wheel.
Okay.
So that's why I'm in agreement, not presenting evidence, because I believe she wasn't.
Yeah, I understand, yes. All right, I'm gonna set the bond at $2,000. And that's what the previous bond amount was. And the court is gonna order regular UAs. The fees will be waived. And Norma, recall this for 30 days, and you're gonna get a reset form and you need to be here. Do you understand?
July 20th.
All right, July 20th.
You can please sign in.
Okay, Ms. Diaz, sign off on this for us, okay? Sign right there where it says defendant. Thank you, Judge.
You're welcome.
Let me get you a copy of this, okay?
Go ahead.